Non-citizen youths currently living in the United States of America who have been neglected, abused, or abandoned by a parent may be able to obtain a green card through something immigration calls a Special Immigrant Juvenile Status, or SIJ. Here to discuss Special Immigrant Juvenile Status is one of Spar and Bernstein's newest immigration attorneys, Jonathan Aftalion. Tell me a little bit about Special Juvenile Immigrant Status.
So Special Immigrant Juvenile Status is a law under the Immigration Nationality Act, which allows minors who are under the age of 21 to obtain green cards if they entered unlawfully or if they overstayed their visas. So there are 5 factors that we have to prove in order to get this Special Immigrant Juvenile Status. You have to be under 21, you have to be unmarried, reunification with at least one of your parents must not be possible, and that's based on either abuse with that parent or neglect of that parent or abandonment with that parent. Even if a parent has passed away, that also qualifies you for this benefit. We also prove that there's a guardian here in the United States that can take care of you and that it's not in your best interest to return back to your home country. So what we do is we meet with these families and we see if the children qualify for this type of benefit.
So, and by this way, when you say benefit, what the child is ultimately getting is a green card. You are making a child legal. Somebody who's here out of status, even if they entered without inspection, even if they don't have any visa status. Jonathan, what is the first step that you do when you file these SIJ applications?
So basically, we go into the family court first. In the family court, the first step is to prove that there's a guardian here that could actually take care of the child.
Now, let me ask you a question. When you say there's a guardian here who can take care of this child, does the guardian have to be an American citizen?
No, Brad.
Does the guardian have to be related to this child?
Not at all. It just has to be someone that's living with the child and that can take care of the child financially, make legal decisions based on the child, help the child go to school, help feed the child, clothe the child.
What if the guardian is out of status? Can they still do it?
They can still do it. You do not have to be in status to be a guardian. And actually, a guardian could even be one of the biological parents. It doesn't even have to be someone that's separate from the family.
What happens now? You go into court and you get this guardianship. What happens next?
So after we go into court and we prove to the judge or to the referee as well that it's in the best interest for this child to stay in this home for this guardian, the next step is to prove the 5 factors that I explained earlier. So we go in for a different hearing, and that's a Special Immigrant Juvenile Status hearing in front of the family court. We send in a birth certificate which shows that the client is under 21. We prove that the child is unmarried. We have the guardianship order that shows that the child is dependent upon the state. And then we prove that reunification is not possible with one parent, at least one parent, and that it's not in the best interest for the child to return back to their home country. Once we do that, the judge gives us an order, and we take that order and then we go into the immigration step of the case.
And what is the immigration step of the case?
So with that Special Immigrant Juvenile Status order from the family court, we file what is called a I360 form, which is a self-petition, and that is the underlying petition which allows you to become a green card holder, and we also file the green card application.
Now, it's a complicated process that I'll be honest with you, you wouldn't be able to do without an attorney, unlikely. But is it a long process? It
really depends on the county that it's in. To go into family court, that normally takes about 4 months. And then once we file the adjustment application, it's another 6 to 8 months.
You're literally talking about less than a year to get a green card.
If you're under 18, we could do it in about a year. If you're between 18 to 21, government is pushing back a little bit. We're still able to do it, but the government is delaying those cases. So 18 to 21, it's running about 1.5 to 2 years right now.
Tell me about a success story that you had handling a case where a child came here to Spar and Bernstein. You were able to do the family court proceeding and the SIJ, and they ultimately got their green card.
There was a case a couple weeks ago that the family came in. They were very worried about their child, who is 20 years old right now, and she was placed in removal proceedings. That's a very scary time for a family. The child didn't qualify for any other possible relief because of her entry into the United States without inspection. What we were able to do was expedite the process of her getting Special Immigrant Juvenile status. This all happened 3 weeks before her hearing, and she was actually turning 21 a week after that. So we had 1 month to get everything done.
And you were able to do it?
We were able to get the family court order, the SIJ court order, and file the self-petition prior to her 21st birthday, and then go back in front of the judge in the immigration court and tell the judge that the I360 is currently pending and allow the government to adjudicate that. Once government adjudicates that, we terminate the removal
So you
proceedings.
saved her deportation?
Yeah.
All at the very last second?
Yeah, we were able to keep the child here from deportation.
Wow,
yeah.
that's amazing, amazing job. Congratulations.
The reason why I love this so much is because it's essentially the new form of DACA, except that DACA was temporary and they're not giving DACA anymore. And people are realizing now how temporary DACA was. Now there are all these children that don't have DACA anymore because they didn't renew it, or it's too late to apply for it. What this does is it gives paths to green cards and citizenship to underage minors.
But of course, with DACA, you qualified as an adult. Here, you got to do all this for a child before the child turns 21. So if you know a child out there, don't let a child grow up in America without a green card, without the ability to make the best life for him or her. Give that child the same chance that I had, the same chance that Jonathan had, the same chance that 300 million Americans had. Give them the gift of being legal in America and let them to be able to stand up on their own 2 feet and be a success based on what they can achieve and what they can do. And if you do know children out there who can be helped, you can always call us here at Spar and Bernstein, 1-800-529-5465. Prior successful results do not guarantee a similar outcome in the future. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.